So we're going to be focusing today on the four pillars of intellectual property: copyrights, trademarks, trade secrets, and patents. And I'm going to talk about copyrights and trademarks. And Ling is going to talk about trade secrets and patents. And so those really are the four main types of intellectual property. There are some more esoteric forms, but when it comes to most startups and businesses, these are the ones to understand and focus on. And so, if there are three things that we want you to take away from this presentation, it's that is the ability, first of all, to identify what type of intellectual property it is that you have, so you can differentiate between trademarks and copyrights. Really importantly, the next thing is ownership. One of the areas that we have our clients struggle with the most is making sure they own their intellectual property, because there are some surprising and unfortunate aspects of intellectual property law that often deprive people of ownership when they've paid for IP and commissioned people to prepare it and all that. And then finally, we'll talk a bit about protecting IP. So first of all, intellectual property, a bit of an explanation. What's the intellectual part? Well, irrespective of whether it's copyrights or trademarks or trade secrets or patents, it all represents intellectual efforts and achievements. So creativity, inventiveness, and the like. And so the property part is, on the face of it, it means it's something that you can own. It has commercial value. And the way to think about intellectual property is that it really gives a bundle of rights to the owner. And so, for example, if you own intellectual property, that may mean that you have the right to sell a product or service, that you may be able to prevent other people from doing so, or even from using your technology. And importantly, also, you've got the right to license others to use your rights. It's one of the, almost unique aspects of intellectual property over other types of property is that it's infinitely divisible. You can make copies and copies and copies of things, and lots of people can use your technologies. Whereas, with real property, there's only one piece of land in a particular instance. So why is it important? Well, it's a valuable commercial asset, and it's surprising to many people, but for a lot of companies, intellectual property is actually their most valuable asset. We'll look at that in a moment. It provides a competitive advantage. Maybe your technology makes your products better, faster, cheaper to make. Intellectual property also can shield you from competition. Take, for example, OLEDs or organic LED TVs. The intellectual property for that's owned by LG. And so that means that Samsung can't make them. And you're probably thinking, well, I'm pretty sure I saw a Sony OLED TV. But Sony either buys those TVs from LG or it produces them under license. So really, when you consider that that's the best technology, TV technology there is, and they have a time limited monopoly to it, it's a very significant business advantage. And then here's an aspect of IP that we're very familiar with in what we do on a day-to-day basis. So when we work for startup companies, we do lots of financings, and if the company goes well, it's usually the case that it gets acquired by a big company, the exit. And at each of those points, the investors or acquirers, and sometimes major customers, they care a lot about IP and they do due diligence. And so they'll want to know, what patents you have, what steps you've taken to protect your intellectual property, what steps you've taken to make sure you're not infringing people's intellectual property. And in some instances, they will walk away from an investment or an acquisition. We had a potential acquisition of a few $100 million about 4 years ago, and the first people to come and do due diligence walked away on the basis of their IP due diligence. And now the happy end of that story is that someone else came along and bought the company. So in that instance, it wasn't fatal. So we know it's valuable, but however, IP is very vulnerable. As I mentioned, it's infinitely divisible. You can't just put a fence around it like real property. It's easy to copy, steal, to counterfeit. So on the subject of value, this is a survey conducted of the S&P 500 over the years, going from 1975 to 2015. And during that time, for the S&P 500 companies, on average in 1975, intangible assets, which is mainly intellectual property, comprised 17% of the value of those companies. Fast forward to 2015, 84% of the value of those companies is attributable to intangible assets, not inventory, not equipment, not real estate, not people, well, people's ideas and the fruit of their efforts, but intangible assets, mainly IP. So when we present this in person, I often ask this question just to begin with. But I think what I'm going to do is, instead of just ask the question and wait for responses, I'll answer it myself. So I went out on the internet to find the most boring example of intellectual property known to man, and here it is. It's a copy of a box of Microsoft Office. I know we all download it now. It doesn't come in boxes anymore, as far as I can tell. But that's the example. And so the question then is, taking a look at that, off Microsoft Office, what types of intellectual property protect it? Well, it's software. So first and foremost, copyrights. The source code is protected by copyright. Object code is protected by copyright. As you may know, Microsoft also has a very large patent portfolio. So there are aspects of that software that are protected by patents as well. If you look at the box itself, you'll notice that there are a couple of, at least 2 trademarks on there. There's the Microsoft trademark, and then there's the Office trademark. So that's a third type of intellectual property that protects that product. And then finally, trade secrets. The fact that when you receive software, you don't receive the source code, and the source code is actually what shows you how the software runs, is a way in which how the product operates is protected. It's a secret. So the thing to think about when you consider the services and the products that you develop and sell is that there are many types of IP. Well, at least 4 main types of IP may all, be represented by your products and services and could be used to protect them. So we're going to start with copyrights. So copyright is, simply stated, the sole right to produce or reproduce a work or a substantial part of it. Now, the important thing to remember about copyright when you're trying to make a difference between that and trade secrets and patents and trademarks is that a copyright protects the expression of an idea, not the idea itself. So if I came up with an idea for a song about a guy whose truck broke down and his dog ran away and his wife left him, and you can guess the genre of the particular song, that in and of itself wouldn't be protected by copyright. It's just an idea. But if I actually wrote the lyrics to that seemingly awful song and wrote some music, and I put that music down on paper, then that would be protected by copyright. It was an idea that I expressed, and once it was expressed, it was protected by copyright. So what's protected by copyright? It's a really broad category of things. So it includes articles and photographs, graphic design, study protocols, if you're conducting research, data, importantly, computer programs, aka software, website designs. And I've got a few examples there on the slide. So one's quite obvious, it's some sheet music. And then we've got the next example is the cover of Business in Vancouver. And what you notice there is that there's not just one work there. There are a number of different works on that cover. So you can take that as a whole and consider it a work, but you can see that there are 2 photographs there. There's at least the beginning of an article and some other text. And so that comprises not just one work, but a whole bunch of different works that are collected together. And that's the same for the Expedia website that I've got next to it. So what do you need to do to have copyright? There are two things. You need originality. So it needs to be more than a copy of another work. And the way that the test in Canada is that it needs to reflect the exercise and skill and judgment, but not necessarily creativity. So the reason why, as some of you that are older will remember, that there used to be this thing called the white pages that they would deliver to your house, and they were quite thick. And they were essentially a list of people's names, alphabetized, and their phone numbers and their addresses. And so the key case in Canadian law to determine whether or not something is original is it was held that the white pages didn't meet that threshold, because it doesn't take much to alphabetize things, and it's a list and there isn't any creativity, or there isn't an exercise of skill and judgment in there. But by comparison, Van Gogh's Starry Night is obviously something that bursts with skill and judgment in terms of how that idea was expressed. So two extreme examples. So that's the first requirement. The second requirement is fixation. So it needs to be expressed in some material form. So if you're watching a hockey game and you see people skating around, that in and of itself wouldn't be, you couldn't copyright that. It's there for a moment and it's gone. But if you were to take a videotape, a videotape of the hockey game, that once the hockey game is in fixed form on the videotape, then it's subject to copyright. So again, that's drawing a distinction between ideas, which are just things that kind of float around, and something that's really in fixed form. Moral rights, kind of an odd concept, and one that our clients trip up on sometimes. What a moral right is that if you're the author of a copyrightable work, then you also have moral rights. And only the author of a work, so that's the sculptor who creates the sculpture, or the photographer that takes the picture, the writer that writes the words, the computer programmer that writes the code, they're all authors, and they have moral rights in Canada. The concept doesn't exist in the US. And here's why it's important. As some of you may recognize that blurry photo in the presentation as being the atrium in the Eaton Centre in Toronto. I'm not sure if they still call it that. And you can see at the top that there's a mobile sculpture of Canada geese. And what happened one year is the people that managed the mall decided that they were going to put Christmas decorations on the Canada geese. And the sculptor who created this, the artist, despite the fact that he had sold the work and no longer owned the work, went to court, got an order, and forced them to remove the Christmas decorations. And the reason he's able to do that is one of the aspects of moral rights is the right to the integrity of the work, and importantly, the right to prevent people from modifying the work. Imagine how critical that is. You hire someone to make a website for you, and then later on you hire someone else to change it. Can't do it. Hire someone to write a software program for you, and then you decide a couple of years later you want to fix some bugs, you want to update it, new version. Can't do it. You can, but the thing is, you would be breaching the moral rights of the author, so the programmer of that code, the creator of that website. And so what you need to do is you need to, in your employment agreements and also in the agreements you have with the people that are not employees who create intellectual property for you, works that are copyrighted, is have them waive moral rights. You can't assign them, you can just waive them. And so what I just provided an example of some language that you could drop into an agreement. And in this instance, it's an employment agreement. And it's just a provision that says the employee shall and does hereby waive all of his or her moral rights in the work product. And so that's what it takes. But you can appreciate that absent that, it would be very bad to be in a situation, and certainly where you have a website where the person who created it originally wants to do updates and doesn't want someone else to touch their work, this could be a basis upon which for them to hold you to ransom. So ownership. Remember I said we're going to think about who owns all these different types of intellectual property. And so for copyright, it's the author. It's the person that actually authored the work. So what's quite odd, again, using software as an example, if you come up with an idea for a program and you even create the architecture for it and draw it on a chalkboard, all the different modules, then you go out and hire someone to code that for you. It's actually the person that codes it that gets the copyright. Despite the fact that you thought of it, sketched it out, paid for it, perhaps if you hired that person. Well, I shouldn't say hired the person, but if you paid a contractor, you wouldn't own that work. It would be the author, the coder that would own it. And so the good news, at least with respect to employees, is that the employer under the Copyright Act owns the copyright of what people create in the course of their employment. But where our clients often have problems is where they're using independent contractors or freelancers, and they're considered the author of their creation. So if you, and the owner of what they make. So again, using the example, if you hire someone to program something for you, you pay them for it, and they give you the code, you don't own the code. What you need is an agreement that says, that they're going to assign the code to you. And what the court will say is, they won't go so far as to say that you can't use it. That would be incredibly absurd. But they will say that you have an implied license to use it. But really, you paid for it, you should own it. So copyright protection arises automatically. You can register copyright, but we don't typically recommend it. The rights that you get through registration are really not much greater than those that arise automatically. The registration is simple and inexpensive, but still, a lot of our clients have lots of different things that are protected by copyright. So you'd come up with a whole list of items, and that could still add up pretty quickly. We do recommend registration before commencing litigation. So what you can do is, if you don't register a software program and then someone takes it and reproduces it and you want to take action against them, at that point you can register the copyright, and then that would provide some benefit for you in terms of demonstrating your rights. One of the good things that you can do is use the C in the circle. So the way you do that is, if you have copyrightable, if you have works that people can see, like photographs, is you would typically put the C in the circle, and then you would put the name of the owner of the copyright and the year it was first published. And you'll see that in books and on websites. So copyright management, focus on the ownership and rights. So one of the things you can take away from this is go back and look at, have you hired anyone to develop anything for you? And if you have, take a look at the agreement, see if you own what you paid for, and ask someone to make for you. And also be sure that there are moral rights waivers. And I'm actually working on the sale of a video game company right now, and we spent a lot of time going back and looking through contracts as part of this deal. And so it is important, but it's really easy to do. You just have words of assignment in contracts and waivers of moral rights. So any questions on copyrights?
Feel free to put them in the chat, or if you want to ask, you can unmute as well. All right, don't see anything, so it looks like we can keep going. Oh wait, there's one.
The website was made for the company who owns it, the designer? No. Well, it depends on what the designer did. That's the interesting part. If you conceptually designed something, but someone else actually assembled it and created the website based on your design, you wouldn't own the design. You'd own whatever sketches that you created in that design. If the website is created by your employee, and if it's part of the employee's work to create your website, then the company would own it, because the Copyright Act says that that what employees, the works that they author in the course of their employment, is owned by the employer. Where and how can we register the copyright? As I mentioned, copyright registration, you can do it. We don't typically recommend it unless you're heading off to litigation, but if you really want to do it, you should go to the Canadian Intellectual Property website. It's very helpful. It's got user guides, and you can register your copyright online. And then if you have any questions, you can reach out to a lawyer. We'd be happy to help. And then there was another question here. In the course of their employment, what if the employees do their own projects in their own time? Do the employer have any claim on that? Typically not. If they do them at home, if they don't use the equipment that you've provided, if they do it on their own time, then not. Sometimes employment agreements have language to clarify that, because it can get a little tricky especially when you're dealing with sensitive intellectual property, and you have an employee that's like learning trade secrets at work and applying those trade secrets at home to make products. And so it can get a bit murky. What would you recommend once you discovered someone has used your copyright information? Well, bear in mind that it's the reproduction of copyrighted works that's the offense. So when you put, but perhaps that's what you mean by use. What we do is we send cease and desist letters to people. Clients say, look, these people are breaching our copyright. Send them a letter. We colloquially refer to them as crapograms, and we do about one a week. And when sometimes our clients come to us and they've received one and we have to respond. So we recently did where the Canadian press had identified that one of our clients was using one of their photographs that they owned. And so we helped respond and advise the client on that. So anyways, I should probably move on to the trademarks part of my presentation and then hand off to Ling. But happy to answer some more questions if we have time afterwards. And I'm sure that I can speak for Ling as well as myself that if you do have some questions that come up, give us a shout, send us an email. The meter's not always running. We'll tell you before the meter starts running. We're always happy to help. So on we go. There we go. Trademarks. Here's a list of there's this international consulting company that does this survey of brands and estimates the value of brands. They do it every few years, and here's their list of brands for 2018. So it's kind of interesting. It ebbs and flows over time, but you'll see, for example, that they valued Apple's brand. Brand is just another word for trademark. At $214 billion. And so that often is surprising to people. And here I'll attempt to explain why it would be worth that much and why the Apple brand is the most valuable asset that Apple owns. And it's simply this, that brand is so powerful that if Apple announces that they're coming out with a new product, almost irrespective of what that product is, people will line up around the block, sometimes camp out for a couple of days outside the Apple store because they're so excited about what Apple produces. And that's the power of the brand. And all that value resides in that brand. I'll give you another example. We do some trademark work for White Spot, and White Spot could disappear tomorrow. Every single restaurant could be closed, every employee let go, the management gone, everyone, the board resigned. cease to exist. And if a couple of months went by and someone came along and re-registered, took all those, took the trademarks and then all the brands, legendary this and the triple O sauce, and then they created a bunch of new restaurants with new employees in different locations, but they all looked the same and they had the white spot brand, people would go to that. Because that's the thing to remember about brands that's what people carry around in their head. That's what connects them to your company, to your products, and to your services. So, ownership. Who owns a trademark? Trademarks are different than copyrights, trade secrets, and patents. You don't own a trademark if you come up with it. You own a trademark if you register it or if you use it in commerce first. And the first use rule applies to common law countries like the US, Canada, New Zealand, Australia, England, and ultimately registration is quite critical. So how do you use a trademark? So using a trademark isn't when it's printed on a circular that you present to the board of directors meeting to decide which trademark we're going to use. It's actually when you use something in commerce. So it's on the packaging for goods, it's on the packaging of the goods, or you can see the Tylenol pill, it's actually imprinted on the pill. Or with services, it includes where you use the trademark in connection with advertising the services. The important thing to bear in mind is if you're a startup company, you haven't gone to market yet, and you've got a brand, you're not using it. So, because you're really not using it until you go to market. And so what's quite critical is that because you're not using it and you don't own it yet, it's just an idea. It's important to at least file a trademark application to protect it. So how do you pick a good, so how do you manage trademarks? Well, first of all, you got to pick a good trademark. And I'll get into that briefly, and then you register it, and then you enforce your rights. I mean, that's kind of a very simple way of looking at it. So how do you pick a good trademark? Well, there are two aspects to it. It needs to not be descriptive, and it needs to not be confusing with your competitors' trademarks. And so what that really means is it needs to be distinctive. The most important quality of a trademark is that it's distinctive, that it can distinguish your goods and your services from those of your clients, your competitors. And so the most distinctive marks are marks like Google and Apple for computers, because they have no meaning, or they didn't have any meaning until, Apple clearly, has meaning in connection with fruit, but certainly no meaning in connection with computers when they started using it. The problem Apple had, though, down the road was when they got into music, there already was an Apple company that the Beatles started. And so they had to resolve that issue. So descriptiveness, simply stated, Volvo can't register or trademark safe cars because that would prevent Mercedes and Toyota and other manufacturers from saying, our cars are safe too, because they'd say, no, you can't say that. So there's an anti-competitive aspect to that. And confusion, you're not allowed to use marks that are confusing with those of your competitors. And there's two reasons for that. The main ones is, first, you're going to infringe their rights and you could get sued. But the other reason is you don't want confusion in the marketplace. You want people, unless you're trying to, ride the coattails of the brand value of your competitors, but I don't think any of you want to do that. You want people to go when they're trying to pick services or when they're selecting your goods. You don't want them to mistakenly get someone else's services or goods, right? That's important. But one thing to bear in mind is that your trademark rights are specific to your field of use. So the example, Delta, 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 Delta in connection with airlines, hotels, and faucets. Nobody's going to go to buy a faucet and end up getting a plane ticket. That's not going to happen. So you can appreciate that, your mark, it needs to be distinctive within your field of commerce, but it could be a mark that someone uses in a really different area of commerce. And if you're looking at foreign markets, you also need to consider the connotation of that's associated with the trademark. So for example, in 1997, Nike put out running shoes with an airflame logo. And apparently in Arabic, the flames kind of looked like Allah. So they were putting Allah on shoes, which is very bad marketing um, in some markets. Now you think they would have learned from that lesson, but in 2020, I think that says 2020, it's blacked out at the end. The Air Max came out, and again, this time was worse. It was on the sole of the shoe. They had a similar logo that also was interpreted to mean Allah, and so that caused considerable controversy and caused them a lot of heartburn. So check the connotation. So quickly, when you're trying to pick a good trademark, you need to conduct some searching and do what we call clearance work. And there's two places you need to look. Remember I said there's two ways to have trademark rights. One is through use and one's through registration. So what you do is you check the registers, and that's easy to do. I'll just show you how to do that just in a moment. But you also need to check the marketplace, because if someone's out there using a trademark, and if they've been using it for 10 years, and maybe it's a small company in Flin Flon, Manitoba or whatever, and you use that trademark, they may have rights to it. You may have missed it. And if it's in your field of commerce, that could cause some problems going forward. And that really touches on that there are two types of trademark rights. I mean, when you register, you get statutory rights, which are pan-Canadian rights, or the rights in any country in which you register, and the common law rights, which are narrower and in the area where you use it. And so how do you do these searches? Well, you can do knockout searches, and then you can order full availability searches. And I'll just quickly show you. So this is the Canadian Intellectual Property Office. You've come up with a trademark, you go to this website, you plug it in where it says enter search criteria, and you see what comes up. Now, the important thing to bear in mind is, again, that's not going to show you if someone's using the mark and never registered it. But this is one of the first steps that you really should do. And also, if you are using the word great, G-R-E-A-T, in your trademark, and someone is using great, G-R, and then the number 8, this won't pick up on that, because it's really an identical screening search. And that's why when you get a bit further down the road, you may want to have some better searches. And this is the US one. So you go to the US, you just Google USPTO tests, and you end up here, and you can do a search in the US. And there are other international search sites that you can use as well. So registration is by country, except for the European Union. It's 27 member states for one price. In Canada, registration, it's becoming a national embarrassment. It's taking so long. So for example, if you go to the EU, you go to the US, you file an application in a few months, maybe 6, maybe 8 months, you hear back from an examiner. They say, oh, we've got a problem with the application, or we think it's fine and you're going to get registered. In Canada, it's now taking almost 3 years just to hear back from an examiner. They're just backed up. And the cost in Canada is about $2,200, including the filing fee and the fees you pay to the lawyers. And there's a 10-year renewable registration period. So as you can appreciate, the cost can really add up if you go to a number of different countries. And so we often say to our clients, when you're trying to decide where to get protection, think about the value of the market and also the likelihood of going there. Like if you're sure you're going to go to Europe and the US and Canada, then definitely register there. If you're not sure about Australia, you could wait and do that later. And enforcement. No one polices your trademark rights. You need to keep an eye on the marketplace. And just like with copyrights, if you find that someone's infringing your trademark rights, you can write a letter, or you can go to a lawyer, and we can prepare what we refer to as a crapogram. And if the crapogram doesn't work, then unfortunately, sometimes you have to proceed to litigation. So just to sum up then, it's great most of you are just starting companies. So you have the opportunity to pick the right trademark. Maybe you've already got one for your company, but when you're trademarking your products and services. Pick one that's distinctive, so not confusing with others, not descriptive. Register trademarks because that gets you the coast-to-coast protection in the country that you're seeking to protect it. You need to, in order to keep your trademark rights, it's a very much use it or lose it. If you have a registration and you cease using a trademark, in many countries, including the US and Canada, your trademark can be struck from the register. And the one thing that I would mention is, and this is great, this is a good advice for companies, not so much for lawyers who are trying to get legal fees, is that as you can appreciate that if the trademarks can become expensive, if you're going to have a lot of trademarks in a lot of different countries, you note that some companies really emphasize one mark. So there are certain car companies, for example, like BMW, where they emphasize the BMW brand, but the cars are all numbers, or for the most part, numbers. So, and they don't have protection for that. So that's a pretty low cost trademark strategy. You know, vest all of your goodwill and your brand recognition in your house brand, and you could save a lot of money that way. Any questions?
Roger, I'll read a couple that have kind of popped up while you've been talking. Kevin's asking, what happens if you didn't do a trademark and then after a year in business, someone else trademarks your company name or logo? Do you have any rights to that trademark?
It depends on what country you're in, because in the Commonwealth country, there are rights through use. So if you're actually in the marketplace using the trademark, you would have some rights. And in Canada, even if they registered the trademark, you could go to court and you could seek for that registration to be struck out. In other countries, it's very much whoever registered it first. And what we're seeing increasingly, when you're all familiar with cyber squatting, which is where people register your domain names in other countries. And then when you go to those countries and you want to get the domain names, and they hold you to ransom. What we're seeing increasingly is trademark squatting. And so what happens, particularly in China, is you start, you roll out a product or service somewhere in the Western world, and then someone applies for the trademark in China, and then you're put in the position where you have to, pay a ransom if you want to use it there.
All right. Brett's got a question. Roger, I don't know if you can see the chat. It's the last question at the bottom. I can read it, but it's a bit
I
long.
have a pending TM for my company. Is that one?
Yeah.
Oh, we just had a few more come in.
Got some more.
Okay. Would the text TM provide the same level of protection for the logo as well, given that the logo is just an artistic spelling of the name? Very good question. So you have word marks, and then you have design marks, and then you have combinations. So usually a company has a word mark like Apple, the word, and then they have a design mark like the actual Apple image. And those are separate trademarks. And the challenge is that you sometimes use them together, you sometimes use them separately. What are you going to protect? For this particular question, if you have the word mark that you've applied for, and someone just takes the artistic spelling, makes an artistic spelling of your name, that would be infringement. And that's what's powerful about the word mark, is if you get the word mark, and we usually recommend people get the word mark registered first, that way if people kind of change it, it's still infringement. But as you can appreciate with a design, the design is really more about the artistic aspect of it. And so once you start to change a design, it becomes less clear that it's an actual infringement.
Okay. Yoni had a question. With your experience, is a simple letter to Google, Apple enough to take out mobile apps from the store that use my trademark?
We have sent letters, and sometimes it is and sometimes it isn't. They are very conscious of participating in the infringement of third-party rights. And so, but I can't, it's not automatic.
Okay, and you may have addressed this, but Katie was just asking where I should register the trademark tests in US or in Canada if your startup's in Canada.
Well, in the US, of all jurisdictions, is the most serious about use. So you can apply to register in the US. Obviously, it's a market that's worth more than 10 times the Canadian market in terms of, you know, the number of consumers. But what happens is before you can go to registration in the United States, you have to file specimens of use. And so if you don't think you're going to be using the mark soon, then you may be better off registering in Canada and then filing in the US because Canada no longer has a use requirement. It's a little bit strategic, but if you intend to be in both markets, I think it makes sense to register in both. But again, I appreciate that people have limited financial resources. But the good news is trademarks are much cheaper than patents. Ling's going to tell you all about that in a minute.
All right, I think that covers most of it.
All right, Ling.
All right. Hi, everyone. I'm going to go off as well, again, just for bandwidth purposes. But just wanted to say hi to everyone.
Okay, Ling's just pulling the slides.
Okay. So I'm going to go and talk a little bit about trade secrets first of all, and then I'll follow that.
Sorry, Ling, we can't see your slide deck.
Oh, okay. Maybe I'll just wait a few seconds.
Okay. Yes. Yes, thank you. No, not yet. No. Maybe I think you have to pick the PowerPoint window. Yeah, maybe unshare and share again, and just select the PowerPoint window specifically.
Ling, what I did was I didn't go to the full screen until I had shared. Yeah, there you go.
Okay.
Now you just got to go full screen.
No. Oh, you're just in presenter mode. So
yeah, I'm just going to switch over. Sorry.
Perfect. Yeah, you know what to do.
Okay, got it.
Looks good.
All right. Sorry, everyone. So I'm just going to talk a little bit about trade secrets and then follow that up with a short discussion on patents. The thing to bear in mind here really is that the discussion really is intended as an overview more than anything. And hopefully, by introducing some of the concepts, you'll be able to at least start thinking about protecting your IP appropriately and be able to spot IP issues as and when they come up. So in terms of trade secrets, these are often referred to in combination with confidential information. There is technically a slight difference between trade secrets and confidential information. I think trade secrets really is a subgroup of confidential information. But for today's purposes and so for general purposes, they are pretty much treated together. So in terms of what is a trade secret, it's really information that is owned by a company that's not generally known outside of that company. And then secondly, the trade secret information generally has commercial value, primarily by virtue of the fact that it is not generally known and is secret within the company. And then thirdly, in terms of what this trade secret, what you have to do really to have a trade secret, you must have shown that you've taken reasonable efforts to maintain the secrecy of this information. Now, some examples of trade secrets and the sorts of trade secrets that we most typically come across are things like know-how, maybe industrial processes, manufacturing processes, maybe formulas, but it also encompasses a lot of what I sometimes refer to as more sort of commercial types of information. So things like marketing plans, maybe you've got financial projections, even business opportunities. These all belong to the same category of trade secrets and confidential information. Now, there are a number of advantages associated with trade secrets, probably the most significant of all being that as long as you're able to maintain the secrecy of the information, it never really expires. And so in terms of its life, you know, it could last for a very, very long time. Secondly, it's fairly inexpensive to protect a trade secret because there's no fines required. You don't have to apply for registration, and you don't have to seek government approval specifically. Unlike a lot of the other forms of IP that we've talked about today, and that we will talk about, things like patents and trademarks, you have to go through an application process. You have to wait a fairly substantial period of time usually, and then if you're fortunate and there's no objections, you know, then you have the protection. In the case of trade secrets, you don't have to do any of that. And as I've given some examples here below, trade secrets can actually be very, very successful. So, you know, examples like the Colonel's secret blend of herbs and spices, the formula for WD-40. You know, these are very good examples of very, very successful trade secrets. And, you know, what's interesting to note is that, you know, had they used other forms of IP to protect that information, for example, in the case of WD-40, you know, if they had gone through the patent route and tried to secure protection for that specific composition, that formula, you know, that would have a definite lifetime. And so typically for patents, it's 20 years. In the case of WD-40, you know, that can last a lot longer because of the fact that it relied on trade secret protection. You know, I think I very often refer to trade secrets as a DIY form of protection because, you know, as I say, you don't have to go to a lawyer to get that protection. You don't have to think about an application or registration process. It's really dependent on what internal measures you put into place at your company. And so in some respects, you can think of it as being very, very straightforward and very, very easy. Although, as I'll mention later, you know, in some cases that can actually become quite elaborate too. So it really depends on the circumstances. Now, some of the disadvantages of trade secrets, however, is that because it is a trade secret, you know, once you let the cat out of the bag, you know, so for example, if you have to share that information with someone else, or perhaps it leaks out of the company and someone puts it on the internet, you know, once it's out, it's gone. And so, you know, irrespective of how, you know, what attempts you may have had to try and keep it a trade secret, once it's known, then it no longer really qualifies as a trade secret. And another concept here is that it's very difficult to prevent, or you can't really protect against independent creation. What I mean by that is, you know, so if a competitor notices your solution and they come up with their own version of it, or maybe they even reverse engineer what you've produced, there's very little that you can do to stop them from doing that. Unlike in the case of patents, you know, if you get the registration for a patent, you can go to court and sue them no matter, you know, where they got the information from, whether they're actively copying you or whether they obtained it in other ways. In the case of a trade secret, if a competitor reverse engineers or comes up with your solution, then there's nothing really you can do about it. And I say subject to contractual provisions, you know, that's in the case, for example, where maybe you have a collaborator or maybe a supplier, you know, maybe there's some sort of contractual relationship there, which says that, you know, hey, I'm providing this information to you. It's a trade secret. We want you to take steps to keep it secret and also not do anything with it other than what's contemplated under the contract. If that collaborator then goes and tries to make their own sort of version of it outside of the contract, then you can pursue them under the terms of the contract. But otherwise, there's very little protection that's available for information that's protected as a trade secret. And then thirdly, there are some situations where trade secret protection just isn't feasible. So for example, if you've got some, let's say you have a product that you're going to be selling, and the trade secret is kind of inside that product. Once you've made it available, once you start selling this product, other people can presumably get a hold of this product, and they'll be able to open it and see how it works. So it's for a situation like that, trade secret will not really work, and you kind of have to look to other forms of IP to protect your innovations. There's one additional risk as well that I should mention. So in the situation where you have a trade secret and you're maintaining it as a trade secret properly, there is still a risk that a competitor may come up with the same solution or a similar solution, and maybe they make the decision to protect it as a patent. And because this information is all still confidential, no one really knows about it, they might well be successful in obtaining a patent for their innovation. And then once they're successful, at least in theory, they would then be able to enforce that patent against you, even though that was an innovation that your company came up with or first came up with. So there are certain risks associated with trade secrets, but if used properly and appropriately, they can still provide a good form of protection. So very quickly, I'll just touch on ownership of a trade secret. This often will arise, and it's really typically technical information that we're looking at here. Where you have something that's been developed by either an employee or maybe by an outside contractor who's not an employee. So once they come up with these technical solutions, the question is always, well, okay, do we own that, and how can we show that we own that? And so, to Roger's point earlier with the other forms of IP, to avoid any potential disputes, you really have to take steps to make sure that you have some sort of evidence or a written agreement saying that those trade secrets that were developed by this other party or employee automatically flow to the company. For most purposes, if you can have something that's written and it's clear, that's going to probably avoid about 90% of the potential disputes. The problems arise when you have a contract that you either don't have a contract or the provisions are unclear. That will lead to a lack of clarity. And it's the lack of clarity very often which leads to misunderstandings and hence potential disputes. So, it's very good and it's very easy, as Roger said, to deal with this up front. If you have this taken care of, then it's much less likely that a dispute will arise. Now, I mentioned earlier that you have to take reasonable efforts in protecting a trade secret or protecting information as a trade secret. There's no kind of hard and fast rule in terms of what you have to do or what steps you have to take. It's really on a case-by-case basis. But generally speaking, what you have to do is to basically show that you've taken steps that you're treating that information as a trade secret. And so you're not allowing general access to that information. So when you are potentially sharing that information with parties outside the company, that you're signing contracts, non-disclosure agreements, or other types of confidentiality agreements, so that you say clearly, this isn't my information. I'm sharing with you for very limited purposes, and I don't want you, or you're not permitted to take that information and do anything with it other than what's provided in the contract. So at the end of the day, it's actually very important, as I said, even though it's a DIY type of protection, it's very important to have a fairly robust trade secret management program in place, where you kind of think through what steps you have to do. You provide kind of education to your employees in terms of how they deal with that information and how they should take steps to protect it. And also when they are potentially sharing that information with anyone outside, what steps they have to do to either be careful or make sure that the other party that they're dealing with, that there's some sort of contractual obligation or other legal obligation to maintain that that confidentiality. So as I mentioned, the measures can be simple, but they can also be very elaborate. So going back to the WD-40 case, I think right now the formula is so secret that at least in the past they had no one person actually knew the complete formula for the for WD-40. It was basically it was split in half, and two people separately knew half of the formula. I think I gather that's changed more recently, that there is now probably one person that does know the complete formula, but over a very large period of years, they've taken fairly extensive and elaborate efforts to maintain that that secrecy. So I'll very briefly talk about how to actually protect trade secrets. These are really intended as a sort of guide more than anything else, because as I say, every case is going to be slightly different, and it probably makes sense to go through the process of thinking about what my trade secret is, and what would be appropriate under the circumstances to protect each form of trade secret. So the key really is identifying the trade secret first. You can't really protect what you don't know you have, and so there are policies that you can put into effect to make sure that, for example, innovations as they come through the company, that they're identified to the extent that they're not written down. Maybe it would be good to memorialize them. Otherwise, it's just residing in someone's head, and what if that person leaves the company? So key here really is to be able to identify it, and it's a sort of ongoing process that you have to adopt. You have to monitor what's being developed, and as it's developed, you have to identify it and say, okay, well, we have this, we have that. What is this suitable for trade secret protection? And if so, how should we best do that? And so, the second point is to really develop a trade secret policy. Those are the sorts of things that I'm referring to. And then, as a part of that, it's fairly important very important to actually appropriately mark the documents. If it's a physical document, let's say it's a lab book or something like that, you want to stamp it as confidential. And generally, you want to try to restrict access to the extent you can. So to the extent you need to share that information with within the company, it should really be on a need-to-know basis. You don't want to have folks poking around the whether it's your physical inventory or your facilities, or to the extent you have sort of databases and things of records, you do want to make sure that information is appropriately marked and protected. And then just I guess a point, particularly with sort of computer and electronic information, there are lots of ways in which that information can get out, and so there's just some examples here in terms of what you might think about in terms of limiting access, either internally from within the company and also externally. The traditional threats that we think about really are so external threats primarily, and things like industrial espionage, when companies get hacked by people outside. So all these potential avenues of loss of trade secrets are very relevant, but in reality, we find that about close to 80% of trade secret loss really is from inside the company, and so that means it's something that you can pay attention to, and you should pay attention to. Very often it may be just disgruntled employees that leave the company, and they decide to take the information with them and share it with a competitor or sell it to a competitor. Or sometimes it just may be inadvertent disclosure of trade secret information. So assuming that you have taken the appropriate steps to protect your information as a trade secret, what does that mean? Well, it means that you can potentially, at least, enforce that on a party that tries to steal that information. And so, as I said, in the situation of an employee who runs off with your lab books and tries to sell it to one of your competitors, if you catch them at the right time, you can stop that. You can, as long as you can demonstrate that it was a trade secret that was involved, you'll be able to stop them from doing so. The unfortunate thing, of course, is that where you have someone who perhaps takes the information and puts it online, that's going to be one of those problems where it's too late. You may be able to go after that party for damages, but it doesn't put the trade secret back into the proverbial bag. And so it's certainly something to make use of, but trade secrets are not are also potentially risky. So that's essentially it for trade secrets. I can't see here if there are any questions.
There's a couple here.
Yeah, go ahead.
Let's see here. So Denise asking, if one is required to disclose a trade secret due to legal action, i.e. subpoena or discovery, does this mean that the trade secret has been disclosed?
Sorry, can you repeat that? I'll just try and open this chat box.
Oh yeah, sure. If one's required to disclose a trade secret due to legal action, so a subpoena or discovery, does this mean that the trade secret has been disclosed?
It could. Now, trade secret is not, trade secrecy is not absolute. So it's not like, oh, if one person knows about it, therefore it automatically kind of goes up in a puff of air and it's gone. If it's limited disclosure, that may actually be okay. So it's not quite as it doesn't go to the extent where you've disclosed it, it's gone. The risk, of course, is that if by disclosing it under subpoena, does that become become a court document and it's widely seen? In that case, then that may well fall afoul of that. So if you have situations like that, then you have to kind of take steps to say, I'm willing to comply with this, and I'm willing to disclose this information, but it is a trade secret. And then you would ask that certain measures be put in place so that that it doesn't lose its qualification as a trade secret.
All right, and Lisa is asking, would you recommend an NDA or NCA prior to any business conversation about trade secrets?
Quick answer would be yes. So the approach we take, for any kind of technical innovations, and this, you'll see that this applies to patents as well. So when you're sharing that type of information, that there are huge risks involved. And so if you have an NDA in place, so a non-disclosure agreement in place, that will at least bind the other party, with respect to their activities. And in addition to actually maintaining as a trade secret, you can impose other things within that non-disclosure agreement. So not only do you want them to not disclose this to other people, but you want to make sure that they take appropriate steps to protect it as if it was their own trade secret. You want to stop them from making use of that information outside of the reason that it's being shared. And so, if you have an appropriate non-disclosure agreement, I would say, almost 10 times out of 10, that's probably the sort of best practice.
All right, that's it for questions.
Okay, great. So moving on to patents. So the situation which often arises, I'm just going to close this. So the situation often arises where you have well, the company comes up with an innovation that perhaps makes your product or service better, cheaper, faster. It provides some sort of competitive advantage. And the goal the goal to protect this is to prevent really competitors from using that same technology. And very often the way we do this is through, excuse me, skip, okay. The way we often do this is using patents. The risk, this kind of follows from the last discussion. If you disclose your invention to the public, then there's a very high risk that disclosee can then turn around and say, well, thank you very much. That's very interesting. I'm not interested in any more business dealings with you, but I'm going to take that information and make my own version of it, or I'm going to use it for my own purposes. And so, unless you've taken steps to protect it, there are fairly significant risks involved. So why even consider a patent? It's because a patent can provide a number of advantages. First of all, it gives you the right to prevent others from, these are the examples here, making, using, selling the claimed invention. And so it's an exclusive right. So, by patenting your innovation, you can essentially keep competitors outside and say, look, this is my turf. You guys back off. As I mentioned earlier, a patent does have a definite lifetime, and it's up to 20 years from the date of filing. So once you file your application, your patent, if you're successful in obtaining it, will have a life of up to 20 years from that date. In exchange for this, you have to fully disclose your invention. And what I mean is, this is part of the bargain that you have with the state. So in exchange for the state giving you this limited 20-year monopoly, you are disclosing the invention to the world. And presumably, the rationale is you're kind of pushing back the frontiers of science and furthering the arts. And so as you do that, you really have to make sure that you are basically teaching the reader of your patent application how to put it into practice. And you can go into fairly extensive detail in terms of, hey, this is the problem that we've identified. Here's the problem so here's the solution that we've come up with, and here's how we put it into practice. So you'll see that if any of you have seen a patent document or a patent issued patent, there are various parts to the patent document, but basically it is just a description of an invention and how it's put into practice. It includes a fairly kind of detailed background of what the issue is and what is the problem that is now being addressed by this technology. How is the problem currently addressed, and what are the limitations of the current state of the art? And then you go into a fairly detailed description of how you apply your new invention. And that at the end of the document is the most important part. It's the claims, and the claims really are the sort of the stakes that the fences that you stake in the ground, really. So they really define the scope of protection. And so anytime you look at a document, anytime you look at a patent document, it's the claims that really are the most important, because they determine the extent of protection that you have. Now, there are a few things, unfortunately, that don't automatically come with a patent. The first is the concept of freedom to operate. What I mean by that is, so if you are successful in obtaining a patent, it doesn't automatically flow that you're entitled to practice that patent. You're certainly permitted, under the patent, you're certainly able to stop competitors from practicing your patent, but it may be that in doing so, you actually infringe upon someone else's patent. So this situation may be, let's say I've come up with let's say someone else has patented a four-legged table and it's protected. If I come along and I come up with the innovation of a folding table, on its face, that would be probably something that I could patent. And so I would get a patent myself for the folding table, and I'd be able to stop others from making my folding table. However, if I then go and try to make my own folding table, it's possible. I mean, it will depend on the claims of the patents involved, but it might be that if in making my folding table, I actually have to make use of the earlier patent for the four-legged table. In that case, I don't actually have freedom to operate. And so, you know, in a practical situation, you know, what you would normally have to do is then you would have to get a license from the other patent owner. So one thing to keep in mind is that freedom to operate does not necessarily follow from a patent. I mean, often it does, but it doesn't automatically follow. And then secondly, and this is very often sort of encountered, bear in mind that getting a patent is half the battle in some respects, because there's no enforcement by authorities. You can't go to the government and say, hey, so-and-so is infringing my patent, you know, please stop them. Unfortunately, you have to be your own patent police. And so not only do you have to kind of monitor your competitors to see what they're doing, if what they're doing is so similar to what you're doing, maybe it is something that falls within the scope of your own patent. You then also have to actually enforce that once you find out that there is a valid case for patent infringement. So very quickly, I'm going to touch on ownership. Again, the same sort of criteria applies here. That I've laid out a bit of a test in terms of how the ownership to an invention is determined. But again, if there's a one kind of take home for ownership, it's really to make sure that you have an express agreement that specifies who owns the rights that are being developed. And so in the case of an employee, if there's an employment contract that spells that out. If you're dealing with an outside contractor, there's presumably some sort of contractor agreement that says, okay, well, so-and-so is developing this technology for me, and any creations that flow from that belong to the company. So it's fairly straightforward to deal with that, particularly kind of before an issue arises. It's much more complicated once there's a very serious commercial innovation that's kind of in play. Then when you have parties kind of disputing ownership, then that becomes a much more of a fight. The second and third provisions, if you have an agreement that is express and clear, then you don't have to go through the more complex assessment of whether the employee was employed for the purpose of inventing, or what's the nature of the employee relationship. Was there some evidence that seemed to suggest that it was always contemplated that whatever was developed by the employee was going to belong to the employee or employer, as the case may be. So take home, make sure that you have appropriate contracts that spell out who owns what. Oops. So I'm just going to very quickly outline the steps in obtaining a patent. So at the very start, I would say the key is to really keep it as a trade secret. And I'll explain why in the next slide. But until you're ready to say, well, okay, now I'm going to sit down with a patent lawyer or agent and assess whether I've got something which I should go ahead and try to patent. Basically keep it as a trade secret, because you never know. But then at some point when it's fully crystallized and you think, okay, this is something which is valuable potentially, I'm going to try and see if it's suitable for patent protection. You go and assess its patentability. Assuming that you get the thumbs up, then the next step is to actually apply for a patent. And that usually begins with a first filing. So you will file or apply for that patent. And to the extent that you're looking at rights beyond one country, then there may be follow-up filings that will follow. And then at some point in the future, there'll be something called examination. So this is when a patent examiner picks up your application and he does a search to determine whether your application meets the various requirements and should be awarded a patent. And then at the end of the day, if you're successful in obtaining a patent, then you have commercial rights that you can fully make use of. And in many cases, that can take different forms. So if it's something which is core to your business, maybe you just sit on that patent and you use it for defensive purposes. You prevent competitors from moving into that space. Alternatively, if it's not something that's very important, maybe you want to commercialize it and try to get some sort of value from it. Maybe you license it to other parties and even sell it outright. And so once it's registered as a patent, it becomes a very valuable asset, and that you can kind of treat as appropriate. So the first step, as I said, was to really keep it trade secret. And the reason, this is before you're even considering patent protection. The reason is because in many jurisdictions, once a patent application until a patent application has been filed, any public disclosure of that invention can basically invalidate that process. So, if you have the situation, for example, let's say you go to a trade conference and you start sharing that technology with the attendees, that's largely considered public disclosure. And so once you've done that, you basically you must have filed an application for that before the event. There are many jurisdictions which have a grace period for this. And so in Canada and the US, there's a 1-year grace period. And so in Canada and the US, you would be entitled to disclose that at the conference and still be within time to file an application. But there are a few countries that don't have that grace period. And in a lot of countries, it's 6 months. I think 1 year is the most common, but there are some which have a very limited grace period, if at all. And so that's something to keep in mind. So even in the situation where you think, hey, I really only care about Canada or the US, I'm not too concerned about other countries, you might actually be basically saying goodbye to at least the option of getting protection in those other countries. Because even if you don't value those countries as a commercial market, it may be something that other people put value on. And so, the fact that you were able to secure, let's say, a patent in Japan, that still can be of value to you. You might actually sell that Japanese patent to someone else. You might license it to someone in Japan. Even though you have absolutely no interest in those countries yourself. So keep that in mind. And as I mentioned, the key very often is to make sure that, to the extent you share information before you're ready to file an application, you make sure that's either under a non-disclosure agreement or some other confidential obligation. I'll very quickly touch on the requirements for patentability. I'm just glancing at the time here. But essentially what we have, you need to have something which is novel or new. So that's a fairly straightforward question to address usually. So it basically just means, has anyone else come up with the same solution that you're planning to protect? The second is usually the stumbling block, and the more complex question, it's whether something is non-obvious. So what that really means is, even though you have an innovation which no one else has come up with, and so it's new, is it so minor of a refinement of what's already known that it would be considered obvious? And if it is, then unfortunately it doesn't meet the requirement for patentability. Third requirement is utility or usefulness. This is a very low bar, it's a very low threshold to meet this. So as long as it has a useful function, then usually then it qualifies as useful. And then finally, subject matter. So this refers generally to, so under the statutes for most countries, and this is the one for Canada, you can have an art, process, a machine, manufacture, or composition of matter as a suitable subject matter for protection. And so as long as your innovation kind of falls within those categories, then you generally have something which is potentially patentable, or it's appropriate subject matter. And so this covers things like mechanical devices, electronic hardware, machines, even chemical compounds and processes. And so those are the more traditional forms of subject matter. More recently, we're seeing a lot of innovations in the computer-related space, and so it might maybe computer software or computer-implemented inventions. These are traditionally protectable as patents. They are increasingly being scrutinized, but depending on how the technology is described, very generally, computer software can still be protected. In the case of business methods, I would say these are becoming very challenging to protect. And so, it will be a useful exercise when you have a useful innovation to kind of sit down with a patent agent or lawyer and say, okay, well, this is what I have. Is this appropriate subject matter, or is this something that I should be using something else to another form of IP to protect? So there's certain things that cannot be protected, and these are things like abstract ideas and something like E equals MC squared or Pythagoras' theorem. Those are just existing. Those are discoveries or scientific discoveries, I suppose, in some respects, but they're not really patentable because they're I guess scientific principles. So the patent process. So assuming you've decided that patent protection is suitable and appropriate, this all starts with preparing and filing a patent application. So you spend quite a bit of time putting an application together that explains what your invention is and how it works. And then once everyone is happy with it, then you send it into the patent office. And as I say, in practice, that application sits for quite a while at an examiner's desk. And at some point in the future, the examiner picks up the application and conducts a search to see whether your application meets the various patentability requirements. So is this something which is novel? Is this non-obvious based on what is already known? And very often it's can be a bit of a lengthy process in such situations, because the examiner might find something which is similar, and then he'll issue an objection or a rejection. And then as a result of that, we have the opportunity to kind of argue against that rejection. Very often it may be that the examiner found something which is similar, but he's misconstrued the prior art, or he's misconstrued your invention, in which case, by explaining certain things, you can kind of convince him that what you have actually is new and non-obvious. And alternatively, if his objections are valid, sometimes you might have to amend your application to kind of change it so that it doesn't fall afoul of the existing prior art that he's found. And then at the end of the day, it ends with a registration. I'm just going to skip through this pretty quickly, but what's important is that the application, the first filing is going to be the most important, because that's where you really put pen to paper and you kind of really flesh out what the invention is. And so you really have to work with your agent and kind of describe what the technology is and how it works. Very often you actually know the technology much better than the patent lawyer. And so, it's a collaborative process in most cases. There is once you have that first application, it's something that's quite attractive to a number of folks. You can validly then claim that your invention is patent pending. So you've got an application for it filed, it's pending. It doesn't necessarily mean a patent is going to issue, but at least you've gone through the process of applying for a patent, and it sort of sends a bit of a warning shot to competitors as well. So, if they're thinking about moving into the same space, they might have to think carefully about that, because if you've got a patent pending, maybe in the event that you are successful in getting your patent later on, that you would come after them and make them back off. So the first filing can be what's called a provisional application. This is available in the US. And so it's really a scaled down version of a regular patent application. As I said, A patent application is fairly detailed document, very extensive, but we're able to cut a few corners when it comes to a US provisional application. But the expectation is that within 12 months of that provisional filing, you're going to have to flesh that out and do a more fulsome job anyway. But in some cases, that can be advantageous for cost reasons, but also in the case where, for example, you've got a technology that is still evolving, where you're still working on it and developing it. The expectations, well, based on what we have today, it's not the final product, but this is what we have today. You file a provisional application, and then maybe at some point in the future, you kind of build upon that with any more recently discovered improvements. Much like trademarks and other forms of registered IP, patents are territorial. So if you apply for a US patent or a Canadian patent, that will potentially give you protection, but it doesn't really give you any protection outside of those countries. So it's not going to protect you in Japan if you don't have an application in progress. But there are a number of things that you can do, because if you today think that I've got 5 countries, or maybe I've got a half dozen countries that I want to get protection, that's going to be fairly expensive. You're going to be looking at 5 or 6 separate patent applications. But there are ways to kind of make that process a bit more efficient and to potentially defer some of the costs involved. So first of all, one thing you can make use of is what's called conventional priority. So similar to the trademark situation, if you file one application first somewhere, it doesn't matter where, somewhere, you're then entitled to file a subsequent application within 12 months of that and claim priority of that first application. So in fact, you can kind of backdate that subsequent application as though it was filed on the date of the first filing. So this can be very useful because you have basically at least a 1 year to decide, do I want to protect this in multiple countries? So you file one application as of time 0, and then you've got 12 months to find out whether commercially it's worth protecting further. And the benefit, of course, is the first costs. And then again, you can make the first application a provisional, presumably a slightly lower cost application as your first filing. Let's skip this. And so in the situation where you're thinking about protection in many, many countries, let's say, a half dozen or so, there is something called a PCT application as well. And we're very happy to kind of go into this in a bit more detail as the situation arises. It's not something typically you'd have to consider right off the bat, but if you are thinking of broad protection, as I say, rather than file 5 or 6 applications, as right at the start, but you can file one PCT or international application. That application allows you to later on convert that into a national application in the countries of your choosing. So that one application kind of reserves that right to later on convert it to, let's say, an Australian or European application. And that kind of pushes back the time frame even more. So rather than 1 year, it's now up to 2.5 years that you can delay that decision of which countries you want to make those filings. And so that quite substantially is going to defer your costs. And this is just an illustration of the, in diagram form, the common strategy that's used when you're looking at protecting an invention in a large number of countries. I think as a rule of thumb, if you're thinking about maybe 3 or 4 countries, the PCT or international filing process pretty much pays for itself. And in most cases, we would recommend considering that when you have 3 or 4 countries in mind. So that's it for patents. I'm sorry I went slightly over. In the PowerPoint, there are a few takeaways that you literally will take away. Because Angie's going to make it available for you. So I'm not going to go into those, but if you have questions, I can address them now. Or I think if Roger's around, we can deal with any other questions on copyrights and trademarks as well.
Thank you, Ling. So for those, I see that we have a few questions on patents, and everyone who asked them is still here. So I'll make sure we get those asked. For those who want to go, because I know we're a bit over, thank you for joining us. Hopefully we'll see you next week. Otherwise, assuming Ling and Roger have a few more minutes, we'll just go through these questions and then quickly wrap up. So, but thank you very much, everyone. Okay, so first question for you, Ling. Feel free to plug Fasken too here. How much for a patent registration and where to register it?
Sure. Just to give you, I mean, it's a guide. The short answer is that it depends. It will depend on the complexity, and it will depend on what type of invention it is. But as a sort of guide, I would say probably about $10,000 to $15,000 is the cost for preparing and filing one single application. Let's say a Canadian application. The bulk of that cost really is the legal time. And so in many instances, particularly with our startup clients, it may be that it's a bit of a collaborative process. And so the client or the inventor or maybe the technical team, sometimes they're able to do some of the heavy lifting. And so they can come up with some of the sort of background descriptions and things like that, which reduce the legal time that's required. And so that is pretty popular, and in most cases it works. I mean, it's not perfect. We still kind of need to kind of go back over that and clean things up and tweak things. But generally, that's the sort of estimate that I would sort of budget for.
Great. Michelle is asking, do you know how to check on a patent application if you haven't heard? And do you know how long they typically take to get back to you?
I think this is where someone has already filed an application. So in many cases, it will depend on which country it is, and even sometimes the type of art in which it applies. That applies. And so, generally speaking, some countries will have the process where you can kind of send a letter or have your agent send a letter and say, hey, when do you think an examiner is going to get to this? And they'll send a reply back, next 6 months or next 3 months. So there is an option to do that, but typically that's really done through your patent agent. There's unfortunately no kind of online database that shows what the processing time for each application is.
Okay, there's a question around international filings from Sharon. I believe it's, I'll paraphrase here. So if you don't file any international patents, does that mean people can use it in any other countries? And the second part, if you do apply for an international patent, do you still apply through a Canadian office?
Intellectual property office.
Yeah.
Yes. So generally speaking, you're right. So there are certain deadlines that you have to meet in order to file corresponding applications in other countries. And if you decide not to take those steps, let's say you file an application in Canada, you decide to do nothing else, then you basically will lose the right to get corresponding protection in those other countries which you've basically abandoned. And so, what that means is that it then just becomes an open field. So, let's say you didn't do anything in those countries, then it's up, anyone can basically move into that market, and it's generally open. So I mean, it doesn't mean you will lose the right to commercialize in those countries, but it certainly will mean that you can't enforce that patent in those countries.
Okay, Claudine is asking, are the results of the invention considered disclosure of the invention itself?
Sorry, maybe I can pull this up.
Yeah. 232, Claudine asked it. Yeah. If you're not sure what that means, Claudine, if you're still here, you can clarify. We can move on to the next question.
Oh, sorry, I don't see. Oh, okay. Sorry, no, I was looking at the wrong thing.
Okay.
I think that I'll try and I think I understand this, but when we're referring to public disclosure, so your concern usually is that you don't want to publicly disclose because by doing so, you start the patent clock running. However, that depends on the extent of disclosure. So to be public disclosure, it has to be what we call an enabling disclosure. So you have to give so much information in that exercise that you're basically teaching the other party how to put it into practice. So it has to be fairly detailed and extensive to be an enabling disclosure. So if you're sharing the results of your innovation, or you're saying this innovation that I've come up with achieves this sort of functionality or has these benefits, that's just sharing the concept. And so for patent purposes, that wouldn't be considered sufficiently enabling. So probably in that case, you haven't really publicly disclosed that invention yet.
Okay, Alexander had a question about the timeline chart you put up. Could the first filing be provisional and followed up by PCT?
Yes. I think, I don't know if perhaps it wasn't clear but I think I did contemplate, at least potentially, that the first application would be a provisional application. And that's probably the more common approach anyway, because as I said, provisional application sometimes is you can cut a few corners. And so the provisional is very often the first candidate for a filing.
All right, and last question, and then we'll call it a day from Anmol. If one is looking to collaborate with companies in the same industry, what would be the best way to ensure your idea is not copied?
There are a number of things that you can do. As we've discussed, we can certainly use things like non-disclosure agreements or any other type of confidentiality agreement. So you're sharing this information, and maybe it's two ways. So rather than just being one way, you sharing information with them, maybe it's a two-way process, and you just kind of customize your agreement accordingly. So you are sharing information. So you're bringing this information, and you would lay that out to the discussion, and the other party is bringing different information to the discussion, and it should be made clear who owns what and what each party can do with that information. And so the contractual relationship really is the most common way to protect that. Ideally, of course, if you've got patents on that technology as well, that just adds an extra layer, or if it's a trade secret. So, if you have that accurately captured in a contract or an NDA, then that's probably going to get you at least part of the way there. I mean, it won't be conclusive, but it will certainly be very helpful.
Yeah, it's Roger here. I would just add that we typically have a collaboration agreement in place that includes a definition for background IP. And the background IP is the IP that exists at the time you enter into the agreement. And then also IP that you develop outside of the collaboration. And we typically have provisions that are very clear that the other party doesn't get to use that. And if they want to, they're going to have to ask and negotiate a license and all that.
All right, thank you for all the questions, everyone. Ling, maybe if you want to go to your second last slide, it just has, I think, your contact info in case people want to screenshot.
Okay, sure.
Perfect. So that's it for today. So everyone, thank you for joining us. Roger and Ling, thank you very much for going over everything. Yeah, Roger and Ling have always been very generous with answering questions after the fact, and I know Faskin is and looks like a very fancy law firm, but they really are a cornerstone of the startup tech ecosystem here and have done so much to support companies even at those really early days. So thank you to Roger and Ling for always being there for us. So
thank you, Angie. And thanks everyone for attending.
Yeah, thanks everyone. So have a great afternoon, and we'll see you next time. Thanks all. Take care.
Bye.
Bye.